So hopefully we have a lot of people in the room already and we can get started. I usually like to wait a few minutes, but I don't think we're going to do that today. I think we're just going to get started because we are also being recorded. My name is Shauna Mackey-Geiger, and I'm the Director of Engagement for the Office of Respondent Parent Council in Denver, Colorado. And my job is to basically support and recruit Respondent Parent Council who do work on an independent contract for us. And I'm joined by Carlin Mast and David Wanger, and I'm going to let them introduce themselves as well.
Hi, everyone. My name's Carlin. I'm a licensed clinical social worker, and I have a background in perinatal mental health, and I've worked with the Baltimore City Public Defenders.
And good afternoon, everyone. I'm David, and I am the supervising attorney for a very long name, the Baltimore City Office of the Parental Defense Division of the Office of Public Defender. And I've been there doing as a supervisor for about 2 years, and I've been in parental defense for many, many years.
I can't imagine how small the font is on your business card. Good Lord. Well, thank you guys all for being here with us today. We're going to talk about separation trauma and how that impacts our work. I come from a long career in criminal defense where I represented the criminally accused and then trained criminal defense attorneys for 25 years. And in doing that work, what I realized was so many of the stories of our clients who were involved in the criminal legal system had come up through the system of family regulation that we call child welfare here in America. And so many of their stories involved separation and trauma caused while they were separated in abusive foster homes and failed adoptions. And it led them to our courtrooms, and we were trying to tell these stories of people. And I thought, I've been here 25 years and it's the same story over and over again. I sort of feel like I have an obligation to go earlier into the system and see what I can do to help and change. And so I came to this work, and almost as soon as I came to this work, I realized the ABA had done this memo, and I want to give credit to the memo because I didn't come to the notion of separation trauma on my own. There's a memo that the ABA put together, and I think that it's available in the materials. I have had interns update the site so that they're easier to get to, and fewer of them are behind paywalls. And then we also had some interns who did amazing work summarizing some of those articles so that you could have better access to it. But that's really was the impetus for me getting interested in the notion of separation trauma. And then I was really fortunate that Mimi introduced me to David, and David brought Carlin to this talk today. But I've been talking about this all over the country because I think it's so important when we think about these kids who are being taken. And part of the impetus for the ABA memo was separation at the border, and it forced the lawyers to kind of get their act together and put some stuff together and file briefs in court and use the social science research to support their legal arguments. And a lot of that work can be seen in the memo. And a lot of the work has been done since like 2016, 2018, when we realized there was a real crisis. But frankly, we have had a crisis here in America and an appetite for separation in America for a very long time. So while the crisis came to sort of the public's attention through these border separations, this has been going on for a really long time. When you look at our history into the founding fathers, what we know is that this appetite for separation happened from the time they landed on our shores. And you look at things like slave markets and the sale of parents from children and the sale of children from parents, and a complete disregard for the family structure that was that of enslaved people, and sort of discounting them as human to begin with. And I think there's a dehumanizing that has continued for over 400 years since we started separating folks on the shores of Africa and bringing them here to the United States as an economic notion. I do want to take a second and ask you guys to make sure if you can, look at the polls. You can just go up into that corner and tell us who all is in here, because it's always helpful for us to know who we're talking to. That just caught my attention. Also, if you have questions for any of us, but particularly in this first part for me or for Carlin, please put them in the questions. It's harder to sort out in the chat. And one of us will mind the question box and see how much we can get to. We don't want to miss out on some of the information for time constraints, but if you have something pressing, please put it in the questions. So moving on from the notion of separating folks to bring them to America to begin with, we've also, since the beginning of American culture, have separated people very recently. You look at the notion of Native American boarding schools, and at the Federal Defender's Office, which was the last job before I came here, I tried the case of a woman who was younger than me, and she was a product of a Native American boarding school. And so that mitigation still exists right now for our Indigenous folks all across the country. And the notion that we would kill the Indian to save the man is really ingrained in the American psyche. And I think if any of you were at the race talk that I just attended before coming to this one, I think that is a source of a lot of the pain points that we see in our system right now. And though ICWA presumes to address some of it, I think that it has done an inadequate job of doing that and preventing separation. And the idea, judges just have ideas that Indian children aren't necessarily as they otherize them. And I think that continues even now on the bench and throughout the other stakeholders and sometimes within our own people. So one of the scariest sentences you might ever hear is, "I'm from the government, I'm here to help." And I think if you ask anybody who had a police agency or a social services agency knock on their door, they would agree with that. So right now, when we look at sources of separation, some of those things are them coming to the doors with child protection warrants and taking kids from mothers and fathers in their own homes and dragging them into care other than kin. And we see kids who are confronted by law enforcement and other government officials and taken to places they've never been to before. Some of the sources of separation are that we are over-policing communities of color and other communities, and we're over-incarcerating, quite frankly. But as a result, we've left particularly communities of color decimated by taking their family members out and putting them in prisons. And, frankly, in the last year, I think the attention has come to how many parents of children have been killed by law enforcement over zealousness and executions. We are arresting Black men at a rate that is terrifying, and we are keeping them locked up. There are over 2 million people incarcerated in the United States, and many, many of them are parents. And then we look at the border separations where policies, not just by the last administration, but by the administration before that, have been terrible in terms of separating families and not granting asylum in ways that are safe and welcoming to folks who are coming to our country through the southern border particularly. You don't see this happening in Canada, I will say that. But I do think the southern border problem has really brought this to the attention of the American public. And that's left a lot of kids in cages where they can't find their parents. And hopefully this administration is doing a better job of locating them and reunifying families, but the damage has really been done. And that damage being done is some of what we know. And I'm going to have Carlin talk a little bit about what that damage looks like once a child is taken from their family and placed with strangers particularly, but even with kin.
So hi, everyone. I'm really grateful to be here. Thanks, David and Shauna, for including me. So I'm going to talk a little bit about more of the neuroscience and neurobehavioral science behind the harm that is done when a child is removed. So my goal is to give you some concrete language and evidence demonstrating the harm of the family regulation system, particularly separation from a parent and a child. So I want to first talk very briefly about attachment theory. It's helpful to understand, and it can be a good jump off point for us to really understand some of the harm that CPS causes. So attachment theory is really just focused on the attachments between human beings, but particularly between a parent and a child. Babies are born with this amazing desire to connect with humans. We are social creatures from the beginning, and it's thought that our earliest attachments to our caregivers kind of mirror attachments we may have later in life and can influence how we perceive things later in life. So attachment theory breaks attachment down into kind of two different areas. One is a secure attachment, the other being an insecure attachment. And within insecure attachment, there are a number of subcategories, but we don't really have to get into that. A secure attachment is thought to be the product of a consistent, present caregiver that is calm and attentive to a baby's needs. Whereas an insecure attachment can be the result of many things, but particularly absence or inconsistency on the parent's end. And one of the things that we look for in secure attachment is emotional regulation. So you can see that oftentimes when you're watching a parent or caregiver consoling a baby, a newborn, it's oftentimes the mother or parent that's able to calm that baby. We see emotional regulation in the form of, when you look at a baby and it laughs back or it smiles at you. A secure attachment is thought to really foster joy and serve as a secure base for that infant or child to go out and explore the world. When it comes to insecure attachment, the things that we often look for are, increased anxiety, crying, very clingy to perceived attachment figures, exploring less, and just a general disinterest in really interacting with others. So you can.
Yeah, sorry.
So as far as attachment and the impact of trauma, it's also important to talk a little bit about the brain. I think this is really going to help y'all when you go into court, and you can use this in your arguments for keeping families together. Neuroscience has taught us a lot, and neurobehavioral science. So I'm going to do a very quick primer on the brain. I am by no means a neuroscientist, so this is going to be very basic, but we can think of the brain as being built from the ground up. So when we're born as infants, we come out of the womb with what's called our reptilian brain already on deck. It's ready to go. And that's responsible for keeping us alive. So eating, sleeping, using the bathroom, crying to let our caregiver know when we need something. That's really the essentials of our reptilian brain. The next thing that starts to develop, and this develops very early in childhood, in the first couple of years of life, is our limbic system. And our limbic system consists of the parts of the brain that regulate our emotion, have empathy, and perceive danger or safety. So it's our fight or flight system. The last thing that we develop in our brain is called our neocortex, and that doesn't really stop developing until we're in our mid-20s. But that's important because it's all stacked on one another. So our limbic system has the potential to positively or negatively influence our neocortex. For instance, if we are raised in an environment where we encounter stress often, or we have a caregiver that is absent from us, we have neural networks in our brain that may wire to perceive threat more often. And that may make it harder to regulate our emotions, connect with others, and respond from a reasonable, rational place in our neocortex.
Oops. Sorry.
Oh, that's okay. So in terms of trauma, I just like to throw out a definition that we can all agree is, a standard definition. And you can breeze through this one.
Okay.
I would say that separation between a baby and a parent is traumatic on using any definition for both people, for the infant and for the caregiver alike. When it comes to the changes in our brain that take place because of this trauma, I want to talk a little bit about kind of the nitty-gritty that goes on in our brain. And hopefully, again, this can help you when you're arguing to have families stay together. So there are potentially very harmful things that can happen when an infant is exposed to prolonged periods of stress, particularly when they do not have the presence of their caregiver. We know from research and science that the most important part of developing a secure attachment and feeling safe is the presence of our caregiver. It's more important than the environment in which we grow up in. So that protective factor of, our loved one, our mom, our dad, or whoever, is much more important to us and our feeling of safety than the overall environment in which we live. And infants that have been separated from their mother caregiver have increased size of amygdalas. And this is very interesting and it's very telling. Our amygdala is kind of our smoke detector in our brain. So it's what alerts us to a potential source of stress or danger. And when we're operating in a place where we have a larger amygdala, one could assume that this means that we may be in a state of heightened stress. We may perceive danger more often, and that would make it difficult to emotionally regulate ourselves or potentially even unlearn that stressor. So moving forward, I thank David and Shauna for allowing me to put this slide in the presentation. I'm assuming most folks here get referrals based on drug use during pregnancy, and I want to very quickly talk a little bit about that. So I'm very passionate about harm reduction and the rights of people that use drugs. So when we're confronting the limitless misinformation about people that use drugs and become pregnant, it's important to remember that with the caveat of alcohol, excluding alcohol, there is no good scientific evidence there are long-term behavioral or cognitive deficits in infants born exposed to substances. Again, as I said, there is a caveat with alcohol. We do know some alcohol use during pregnancy can be harmful, but with other substances, particularly a lot of the illicit substances, there is no good research to suggest that. And as I point out in this slide, environmental factors, just like poverty, economic insecurity, food insecurity, racism, have a much larger impact on gestation and health of pregnancy than substances do. I think it's really important to combat misinformation, particularly around drug use. I know my experience having worked in perinatal mental health. I worked in a hospital and provided services in a NICU on labor and delivery and mom baby. I often saw that people giving birth that had used drugs during pregnancy, particularly opioids, were often, it was attempted to separate the mom from the baby because of stigma and how we feel about moral drug use. But it's actually really important to keep them together. So we know that neonatal abstinence syndrome happens. It can happen when a baby is born exposed to things like opioids. And, I used to tell folks, it can be really hard to see. Withdrawal is not fun. I'm a person in recovery. It's awful. But the beautiful thing about NAS is that it's transient. These symptoms will be alleviated, once the baby has been given some time. The most helpful things that we can do is keep mom and baby close for soothing. So skin to skin, breastfeeding, if that's something that the parent is comfortable with, keeping the lights low, the noise low. But that presence of the caregiver is very soothing to the baby and can really be helpful. So I hope this helps.
And Carlin, it seems to me that knowing what we know about the research on separation, there's more risk of damaging a baby's brain by separating them from their caregiver than by allowing them to withdraw and remain intact. And that separation trauma can last a lifetime.
Absolutely. So we wanted to briefly talk about ACEs. That's a pretty seminal study that was done that talked about the impact of certain life experiences during childhood and quantified that into a number that would later, be used to be linked with certain illness, certain psychiatric issues. And we know that being in foster care and being separated from our caregiver is one of the most harmful things that can happen and is highly correlated with illness later in life.
Later in criminal defense, a lot of times when we're looking at what are the mitigating factors in a case for purposes of a sentencing or whatever, sometimes these ACEs numbers are really important. And what we can do in the system that we work in is try to limit try to not create an ACE for your client or for your client's child. So what we do know from the research is that children are twice as likely to have learning disabilities and developmental delays. And these citations are in the files that are included, have lower earnings as adults, have higher teen birth rates, and are more likely to have substance-related and mental health disorders. So, Carlin, do you want to talk about other harms that there are?
Yeah, so
I can if you want to.
you can, yeah, feel free, go for it.
And I think this bears out when we see them in the criminal system. They're 6 times more likely to have behavioral problems. So when you see the school to prison pipeline, as we do, or now the foster care to prison pipeline, a lot of times what we do is criminalize these behavior problems that are caused by the fact that the Department of Human Services has created this trauma for this child. And of course they're acting out because they have been harmed and traumatized. Their delinquency rates are higher, so we see more kids coming into court once they've been separated from their caregiver. And as adults, they have arrest rates 2 to 3 times higher and are more likely to have criminal convictions for violent offenses. I think one of the things that I learned in doing criminal work, and particularly in the death penalty field, is so many of the violent offenses come from a place where separation trauma is part of their background and their mitigation story. So there are risks for keeping parents or families apart. And so some of the things that you can look for to strengthen your arguments are, what are we seeing at review hearings? You'll see the guardians ad litem or the county attorneys come in and say, oh, this child is regressing, is wetting the bed, is not sleeping well, is not eating, is hurting other kids in care. And those are all symptoms of separation trauma, which has been caused by the court proceeding in and of itself. And so we're going to talk to you, and David in particular, with Carlin's help, is going to talk to you about how do we address this with the court. Like, it seems like what gets argued is these behaviors are the result of bad parenting, when really these behaviors are often the result of the trauma imposed by the court proceeding itself. And so I think you need to be really aware of that when you're doing a review hearing, so that you know what you're addressing and you don't buy into the notion, sort of like the propaganda that Marty talked about. Don't buy into this notion that it's your client's behavior that is leading to these symptoms in the kid. Think about, how can I argue that this can be ameliorated by reunification? So from a nuts and bolts perspective, David, please tell us what we do with this information.
So as you've heard, Shauna has given you a very wide scope on separation trauma and what happens to all kinds of populations and people are being separated. And Colin's given you a lot of the science and a lot of the information about what happens to children when they've been separated from their parents. And I think what I'd like to do now is sort of narrow our focus and bring us into a very practical way of how are we going to be using this in court. And I think the first thing I'd like to suggest is that I've always sort of been ambivalent about the name defender and being a defender. I like to think of myself as being on offense and not on defense. And I think we can use this issue to be affirmative, to be on offense, to be explaining why our family should be intact, as opposed to defending against an effort to divide. And so where this probably comes most into focus, just typically in removal hearings or shelter cares, whatever they're called, that immediate harm that is being done to a child, particularly an infant, and we're going to focus on infants in a moment, but all children who are separated, adjudications, and then particularly in dispositions, we want to, again, as I said, take the offensive, change the narrative, and put the focus on why the state is harming this child, not the parent. And I think this fits in really well. Marty gave an amazing talk today. He's just each time is better, and this time he really was going after it. So I want to talk about and a situation or case I had where my client, Ms. T, and her son, Jay, Ms. T and the father of Jay were undocumented parents, and they brought their 4-month-old child, Jay, into the emergency room, and he had a really severe skull fracture, to the point where ultimately he was going to need brain surgery because his brain was escaping through the displaced fracture in his skull. and the parents had no explanation for what had happened, and they were the full-time parents for Jay. They lived in a home with a couple of other people. They were pretty much around Jay the entire time, and they had no explanation. At adjudication, this came to a battle of experts, and to my surprise, the department actually made an agreement at adjudication that there was a disagreement as to whether or not this injury, or there was a possibility that the injury was caused by either abuse or by an accident. And we were headed to disposition, where, of course, the department and the child's attorney wanted Jay to stay in foster care. And we, of course, were looking for reunification at disposition. So we had to come up with a strategy to convince a court to take what they would consider a risk and place a child who had a serious brain injury back in the home where there was no explanation for what had happened. Our strategy was to convince the court and demonstrate to the court that the damage being done to Jay being in foster care was much greater than the risk of the harm that could occur were he to be returned, and to prove to the court that there was an attachment between Jay and his mother, and that breaking that attachment would do tremendous harm to him for the rest of his life. So we first did the discovery and gathered all of the medical records, and fortunately had the ability to have a intern in our office, a law school intern for the summer, read through the hundreds of pages of medical records and highlight each time our client, Ms. T, was with Jay and the observations that were made. And then we were able to share that record with our expert, who happened to be Carlin, to review the records and present her as an expert to the court. Of course, I lost it. Present her as an expert to the court, and explain and take the offensive and have our expert explain to the court what damage the department was doing to this child and what importance there was to returning the child to Ms. T and the father. And so to help with that, Carlin and I are going to do a direct exam. It's brief, it's sort of narrowed down, obviously, for an interest of time. For those of you who have been trained in the chapter method of crafting directs and crosses, I'll let you know I've got 4 chapters that we're going to go through, so you have an idea of what we're going to do. First, establish credentials for Carlin and offer her as an expert. And one thing to keep in mind and think about while I'm doing this is it's really important what you qualify your expert in. And so I'm going to take care in making sure I qualify her in a subject that's going to be the most important and most helpful to us. The second chapter will be to have Carlin explain what maternal infant attachment it is, how it forms, and how important it is to the development of a child. My third chapter will be about Jay and the nature of his relationship with his mother. And my final chapter will be the benefits of keeping Jay with his mother and the harm in separating them. Okay, so I'm not sure if we're screened the right way, but I hope so, and we're both can be seen.
I think I've done my part, so I hope that you guys look good. And I'm just answering questions in the chat rather than interrupting you, so I hope that's okay.
Okay, so we'll get started. So please state your name and occupation.
Carlin Mast, and I'm a licensed clinical social worker.
So let's start with your education. What is the highest level of education you attained?
A master's degree of social work.
And where did you receive your degree?
The University of Maryland, Baltimore School of Social Work.
And what did you do to receive a master's degree in social work?
You complete 2 years of studying as well as 2 clinical graduate internships.
Uh, let's discuss your licensures. Do you have any licenses in the field of social work?
Yes,
Or what licenses do you have?
I have a licensed clinical social work in the state of Pennsylvania, and from 2015 to 2019, I was licensed in the state of Maryland.
And what did you have to do to become licensed?
To become licensed, you have to complete school. To obtain your first level of licensure, you have to practice for about 2 years under a higher level licensed professional. You complete an exam, and then you can practice at your highest level of licensure. So graduated and 2 licensing exams.
Let's move on to your professional employment as a social worker. Have you been employed as a social worker?
Yes,
And where have you been employed?
I've been employed at Jefferson Behavioral Health in Philadelphia and the University of Maryland Medical Center in Baltimore.
And what do you do at Jefferson?
At Jefferson, I am what's considered a behavioral health consultant. I do therapy in a primary care clinic.
And what did you do at the University of Maryland Medical Center?
At the University of Maryland, I provided clinical services on several different floors. So on labor and delivery, mother baby, in an abortion clinic, and an outpatient clinic for high risk pregnancies. I was considered the perinatal social worker.
Finally, I want to talk to you about your experience and training in the area of secure maternal infant attachment. First, can you tell the court what a secure maternal infant attachment is?
Sure. So maternal infant attachment, as I mentioned, is a bond between a caregiver and a mother. It's classified as a few different categories, secure being one of them. So a secure attachment is thought to consist of several different things. It is thought to consist of being able to soothe a child, being able to facilitate joy, and serving as a secure base for which the child is able to go out and explore. The most important factor in a secure attachment is the presence of a parent or caregiver.
And have you had any specialized training in secure maternal infant attachment?
Yes, I studied secure attachment in general in graduate school, and I was in a research study that researched attachment and memory.
So now I will offer Ms. Mass as an expert in social work and in secure maternal infant attachment. And fortunately, the court agreed. Chapter 2. Ms. Mast, I want to start with getting an understanding of what maternal infant attachment is, how it forms, and the importance of it to the healthy development of a child. How is a secure maternal infant attachment created?
So a secure maternal infant attachment is created. It starts when a fetus is in the womb. A fetus hears its parent's voice, feels the sensation of their voice, and it continues after a baby is born. Like I said, the most important factor in a secure attachment is a consistent presence on the part of the parent, creating a safe, calm environment for the baby.
So what are the benefits of a secure maternal infant attachment?
So the benefits of a secure attachment can be seen early as well as later in life, because our brain is developing so quickly when we're born. The things in our brain that develop, kind of the most important things that are developing in the first few years of life, is our sense of danger and safety. Our emotions, our empathy is also developing at an increased rate as well. When we feel safe and we have a consistent caregiver, we are able to engage in developmental play that is appropriate. We feel safe and secure, so we're able to engage our senses and do things that children typically should. This can help with our emotional regulation and our ability to relate to others as we grow up, and can increase our emotional intelligence.
And what are signs of a secure maternal infant attachment?
Signs of a secure maternal infant attachment include the ability to calm a baby on the parent's part, So for instance, if a newborn is inconsolable, uh, usually there's one person, typically the mom or parent, that's able to console the baby and calm them. We often see in secure attachment that if a mother or parent and child are together, the child feels safe enough to explore and play while the mother is there. If the mother leaves, the baby may get upset, but is able to be calmed down when the caregiver returns.
And what are the effects if an infant of 4 months of age who has developed a secure attachment to his mother is separated from his mother?
So the effects of separation can be extremely harmful, particularly at 4 months. What we know, what neuroscience has taught us, and brain development has taught us, is that when an infant experiences separation, they experience stress. And what this does is increases stress hormones in their brains, particularly cortisol, norepinephrine, and epinephrine. And even for just a little while, if those stress hormones are increased and they persist, that can rewire our brain in a way that we stay in a place of fight or flight when we could have kind of de-escalated and feel calm. Because our brain is developing so quickly within the first few years of life, this does have the potential, like I said, to put us in a place of fight or flight, to have us perceive the world as a dangerous place. And that can impact our ability to think rationally, relate to others, and have empathy in the future.
So let's talk now about Jay and the nature of his relationship with his mother. Jay's medical records, with some of the portions highlighted, have been admitted in this case as Mother's Exhibit 2. Did you have an opportunity to review those records?
Yes.
And having reviewed those records, can you tell us whether those records contain information that would allow you to assess, based upon your training and experience, whether a secure maternal infant attachment had formed between Jay and Ms. T?
Yes.
And what did you see in the records that aided you in making that determination?
So throughout the records, Jay's mom is noted as being present almost daily. She's consistently there, which is, as I mentioned before, the most important part of obtaining a secure attachment and fostering safety for a baby. There was one instance in particular where the baby was not able to be soothed by several different nurses. And when Jay's mom was finally able to comfort him, he immediately calmed down. She was also noted to be involved in caregiving and clearly very active in his care.
And based upon your education, training, and experience as a social worker, and more specifically in secure maternal infant attachment, do you have an opinion as to whether a secure maternal infant attachment had formed between Jay and Ms. T?
Yes.
And what is your opinion?
My opinion is that they have secured a secure attachment. They are pair bonded, and he feels very safe with her.
What do you base that opinion on?
Both the medical records and my experience working with attachment.
Now, finally, I want to have you talk about the benefits to keeping Jay with Ms. T and the potential harm in separating them. Are you aware that after leaving Mount Washington, Jay has been in a foster home and visiting his mother once a week for an hour to an hour and a half?
Yes.
And based upon your education, training, and experience as a social worker, and more specifically in secure maternal infant attachment, do you have an opinion as to how that separation from his mother would affect Jay?
Yes.
And what is your opinion?
I think that separation could be extremely harmful to Jay's development and the development of his brain.
And what do you base your opinion on?
I base my opinion on both my experience in maternal infant attachment as well as neuroscience.
And based upon your education, training, and experience as a social worker, and more specifically in secure maternal infant attachment, Do you have an opinion as to whether continuing Jay in foster care with weekly visits with his mother would affect him?
Yes, I think it would cause harm.
Okay, and what is the basis for your opinion?
My basis for my opinion is my education in maternal infant attachment and brain development.
And what harm do you anticipate will happen to Jay?
So I believe that it could negatively impact his brain development, particularly his limbic system. Um, any spike in hormones and stress hormones, particularly cortisol, norepinephrine, and epinephrine, even for a short period of time, has the potential to rewire our brain, our limbic system, to perceive threat and danger more often, and can impact the way that we emotionally regulate and our level of empathy.
And based upon your education, training, and experience as a social worker, and more specifically in secure maternal infant attachment, do you have an opinion as to the effect on Jay of returning him to the care of his mother?
Yes,
And what is your opinion?
that he should be returned to the care of his mother.
And what do you base your opinion on?
I base my opinion on my education in maternal infant attachment as well as brain development.
And what do you consider the effect would be on Jay of returning him to the care of his mother?
Returning to the care of his mother would allow him to feel safe and secure with her, which would give him the opportunity to engage in developmentally appropriate exploratory play, and perceive the world as a safe place.
Okay, I have no further questions. Thank you.
Thanks.
So that was a somewhat scaled down direct. And one thing that I think is important to talk about in this area is, to be frank, I was not thinking we had a really good chance of getting a disposition of return to Ms. T. But what I wanted to do was to significantly increase the visitation that was occurring. And I think that this is really something that folks focus on greatly in their dealing with cases from the beginning. We know that parenting time is the most crucial factor, in my view, of bringing about reunification. And once a week for an hour to an hour and a half is for an infant, I guess it might as well not be anything, because by the time the week is up, they don't remember the person from the week before. And so we very much wanted to increase the visitation. Turns out the judge granted our request that Jay go home. And despite the very serious brain injury that he had suffered, the court ordered reunification that day with a lot of services and a lot of protections. It went through, the department took an emergency appeal, and actually this child went through another separation from his mother late in the evening, as the Court of Special Appeals issued an order to remove the child. But a week later, we were successful again in getting Jay returned. And 2 years later now, he's doing well. And it took 1.5 years, but the case closed. And so I think that the lesson I took from this, because I'll admit it's not something I do all the time, is that we need to be much more affirmative and aggressive in our approach to the harm that's being done. I think Marty's talk was very much focused, and I agree with him 100%, on all of the things about the system that are terrible. And I think that what we need to do is take that same concept, that this is a horrible system. We shouldn't be the defenders. We're not on the defensive. We're protecting the family and keeping the family together, and using the expertise, using the science. Sometimes we let the science be turned against us, we need to turn the science on our behalf and use it affirmatively. And I know we've experienced it in hiring social workers, and there are a lot of people out there like Carlin who are in the view not CPS social workers or caseworkers, but who understand the science of separation. If we take ACEs and change the focus of ACEs from the harm the children are suffering and turn it into the harm that the system is doing to children by separating them from their parents and putting them in foster care, we use the science, use the experts on ACEs, not to separate families, but to put families back together, to understand what our clients are going through. And I think that it's important for us to understand, and this helps us in working with our own clients, which is sort of the last piece of this I'd like to talk about. Our clients are very often have had their own separation trauma. They are graduates of this system. And when we work with them as their lawyer, we need to understand that. That's one of the greatest benefits of having social workers work with us as part of our team, is understanding that, helping us understand that, helping us understand how to communicate with our clients and how to deal with the fact that they're hypervigilant. They don't want to be in a courtroom. They hate being in that courtroom. They don't want to deal with the social worker. They don't want to deal with the caseworker. And so we need to understand those facts and what separation trauma has done to children and bring it into the courtroom on behalf of our clients. So with that, I'll turn it back to Shauna for closing and for also to go over, do we have questions and whether we have questions to review and go through.
I'm going to pull back up the PowerPoint so we can talk about a couple more things. And hopefully that shows us what you need to see. One of the things I think that's important too, when we talk about, one of the big motivators for courts in courtrooms is we are here to protect the community and community safety, and that's why they don't let folks out on bond and all of those things. I think we need to start arguing that this separation trauma is causing not only harm to the child, not only harm to this family, but harm to the community, because the judges are destabilizing communities every time they take a child out. And I think that they need to be thinking about that more long term. And we are so wrapped up in like the safety of the child in that moment that they aren't thinking about the safety of the child long term, the impact it has on the family, and the safety to the community if we're taking kids out and causing permanent brain damage. And I think we need to start making those arguments to the courts at the removal hearing, because courts aren't thinking, what's the prejudice of me doing this? They're thinking in that split second, they react from an emotional place and from their gut. And there's been a lot of discussion in the chat, and I want to hear David's input too, because I've been just typing answers. But one of the concerns is getting in some of this research. And do we have to have an expert to do that? And a lot of people aren't going to have the funding or the time to get an expert at the time of removal or shelter hearing. So one of my suggestions was filing a motion. And I think you stand up and argue the research at a removal hearing the same way you would argue case law. Have it with you. Have a notebook that has those articles in front of you so you can hand one to the other side and to the guardian ad litem and to the judge and say, this is what the research shows, and this is the harm that you are doing to this child, and we have to do the balancing. And the research is very clear that a child is better off in a marginal home than it is being removed and having the trauma of separation. And I think you just need to go in there in a position of leadership, as David suggested, and say, we're here to tell you the science behind this, and what you're about to do is going to cause long-term consequences to this child's brain and to this community as a result of those consequences. So there are some questions about how to get that information in. David, do you want to?
Okay, so yeah, well, I want to talk quickly about the question about at removal. there are a couple of things I would say. One, especially in this era of Zoom, um, it unfortunately, because Carlin wound up moving, it didn't work out, but we were trying to line up Carlin as sort of an on-call expert to use in the right case, in the right situation for a shelter hearing. And especially in the era of Zoom, it's depending upon the way your own expert witness system works. For us at the Maryland Office of Public Defender, we're part of the statewide Maryland Office of Public Defender. We have our own forensic unit, which allows us to hire experts, and we frankly can get an expert hired very quickly if we want to go through, if we have what we need to do to put the expert on and testify. So we don't have to go to the court to get permission to hire an expert. We don't have to go to some other agency or outside group to permit us to get an expert. So I guess we're in a different position. One thing I would suggest you do, particularly because I assume it's the same, that the rules of evidence are often not applicable in a removal hearing. We had Carlin write what we called a clinical brief, explaining very briefly this exact brain science issue of what happens to infants when they're separated from their caregiver. And you can have her draft that, sign it, and offer it at shelter as evidence of what the impact is. It may not avoid removal, but it's something that we wanted to use particularly with infants to get visitation or get parenting time that was far in excess of that 1 hour a week. And so we would use that. You could use that kind of clinical brief. So if you want to get evidence in, you don't have the ability to get witnesses at a removal hearing, then you can have a brief written. As far as if you're not able to get experts at all, it is obviously that's going to be really challenging, but you can use, well, in Maryland, it's 803, federal rules, it's 803.18, that allows for the submission of treatises and other documents. So you can get articles that have been written about secure attachment and what it is, and you can use that to examine the department's witness. They're not really experts, in my opinion, but they're someone that you can at least try to put a treatise in or some other document to make that argument with the court. But if you're not able to get experts. I do see a question I wanted to talk about, an interesting question that comes up about Eric Johnson asks, I heard nothing about from a reasonable medical probability, a reasonable medical certainty in the damage testimony. People who know a lot more about this than I do have said that idea of reasonable degree of certainty is sort of, it's not in the rules. It's not really in case law. It's developed. I think if you dig deep into it, it may have come from the Fry-Reed definition of what an expert could do or say, which is now no longer applicable anyway. All the rule says is that an expert can give an opinion if based upon their knowledge and experience, their opinion will aid the fact finder and they have a basis for their opinion. So you may be if you're in a jurisdiction though, and you may be in one, or you may have a judge, or you may have a court that thinks the magic words are based on a reasonable degree of certainty in your field, then use that language. I didn't use it only because it's not, I don't think it's necessary, and I don't really know. I'm curious how they would define that. How would Carlin define a reasonable degree of certainty in her field of social work? I don't really think that exists. And I don't think it exists in medicine either. I think that's made up. And so I would avoid it if you don't need it. But if you're in a jurisdiction where they use it, then use it. Because the expert's going to know it. Your experts are going to understand that those are the magic words. And it's fine to use those magic words if that's appropriate. I think there's a question there maybe for Carlin. And I may have lost it.
Is it the one about secondary caregiver attachment? So, Carlin, the question is, I'd like to hear a bit about
I'm sorry.
Can you hear me? It says, I'd like to hear a bit about attachment to a secondary caregiver, meaning the caregiver other than the birth mother. She'd like to be able to use this information to argue against removal from a significant caregiver other than a bio mother. And I think it gets used against us all the time, right? When they've managed to keep the kid in foster care for so long, and then they're like, oh, we can't take it from the foster mother because too attached. So how do we use that if the caregiver is not mom?
So I think that can be a little complicated, but thinking it doesn't always have to be mom. There are plenty of caregivers that don't identify as mom or are birth parents. I think the most important thing, I want to make sure I'm understanding this correctly. You want to hear about secondary attachment because can you explain again to me why? I don't think I understand.
Just to be able to use the same information. I mean, does it apply to any caregiver or does it have to be a bio parent?
No, it applies to any caregiver.
Attachment theory applies regardless of whether it's a bio caregiver, right?
Absolutely. It doesn't just have to be the birthing person that is the source of attachment. I think as long as, there's just consistent present, feeling of calm and security, you can achieve the same results.
Well, and there's a question about how we suggest convincing a court that separation trauma is more significant than potential trauma to the child being placed with bio parents who have significant substance abuse issues. And I think this goes back to what Carlin was saying about drug tests aren't parenting tests. And if you look through the research that's in the files and you read that whole memo, it makes it very clear that the risk of separation trauma outweighs a lot of other risks, including it outweighs the fear of potential harm. It outweighs often, I'm just going to say, think about how many white suburban moms are like, is it wine time? And nobody's taking their kids out of their care. And parents are often able to successfully parent and navigate a substance abuse disorder simultaneously without causing harm to the child or the child's brain or the child's ability to function. And I think you just need to address it head on and understand your client and understand what your client needs and understand the client's trauma as well and build that into a treatment plan and talk about what is a less drastic alternative. It is a less drastic alternative to shore up an addicted parent than it is to take a child out and risk harm to their brain and creating an adverse childhood experience for them. And I think you just have to feel secure in your arguments about that.
I don't think you.
And I think also can I?
Go ahead, Carlin.
I'm just going to quickly add. I think we have this very heteronormative, white, paternalistic view of what an acceptable childhood is. And the reality is most of us live in chaos, right? So to take away this hugely protective factor of a secure attachment with your caregiver, to then put a child into foster care where it's probably going to be very chaotic and then not to have that protective factor, it just makes no sense to me. It's so harmful. Yeah.
What were you going to say, David?
Well, Colin said it a really great answer. And my comment to that was only going to be, you may not convince the judge the first time because they're set in their attitude that someone using drugs can't take care of kids, and a kid can get adjusted to foster care. It'll be tough for a night or two, and then they'll be fine. And our job is to educate the court that that's not true, and they need to hear from experts to tell them that's not true, and give these information of what's happening to kids who go through foster care as adults and what's impact on what's the trauma of separation is greater than the trauma of having a parent who's getting high.
When I think there's some questions about, and I think this was importantly stated by Carlin, we do operate from a heteronormative perspective a lot of times. And so a lot of this we've talked about in the context of birth mothers and mothering as a general proposition. But I think this separation trauma can be applied to non-custodial fathers or custodial fathers or to siblings. All of that separation impacts them the same way. And that's why it's interesting to me, because we're very big, and guardians ad litem are very big on we have to keep siblings together for all of the scary reasons that we're saying you need to keep kids with parents. So they know what the research is. They just pick and choose and decide to use it when it's convenient for their arguments. Well, it's always convenient for our arguments. And so you need to go in strong, treat these research articles just as you do the law. They are science, particularly when the rules are relaxed. Bring them in, hand them over. If you're doing it by Zoom, provide them as documents online, email them to the judge, get them in front of the court, force them to read these things. And it is hard because, as I think it was Heather pointed out, you can't sue a judge if they make a bad decision. They have immunity, they're operating from the gut. We have a judge here who was just removed who just said, I'm just operating from my gut, and locked up a mom for 9 months for contempt without even looking at the rule regarding contempt. And so she also walked off and left the record running during an ICWA proceeding and was like, I don't need to hear this. I'm not going to make a decision, but you guys can keep talking. So judges are acting with impunity. It is our job to know the most about our clients, about the research, and about the law, and be leaders in that courtroom. And eventually, if you keep doing that, the court will look to you to tell them what to do. And it takes a long time. It's a cultural shift, and we have been beaten down. Marty pointed out today, we are always the redheaded stepchildren of the courtrooms. We're the ones who represent the abusers, and that's not true. The abusers are the Department of Human Services, and they are causing more harm than these parents are causing on a micro level. They are causing huge harm on a macro level, and you just need to get that to the court through the research. And there was a question about the park. I think that Park et al., the 2016 study, Carlin, I think was in one of your slides. Do you have that full citation? Somebody was asking for that. Oh, that's in the.
Yeah, give me 1 second. I can pull that up.
I think we were putting a list of resources also in. We'll upload those to files. That would be on that slide that you had all the citations on. So we'll make sure to get that uploaded into the files as well.
Oh, yes.
So if you just put that up as a PDF, they should get it.
Yes, give me 1 second.
And I know that this presentation, we talked about it through a frame of biological attachment, but I want to reiterate what Carlin was talking about in terms of attachment theory. You're attached to a caregiver, and I think Carlin used the term caregiver a lot during her talk. So any of this would apply to a long-term caregiver, or a lot of families work in different ways, and grandma may be the caregiver, or whomever is the matriarch or patriarch of the family. All of those theories about attachment still apply.
So I see a question here from Maggie Potter. If you have a social worker on your staff, how do you utilize them to inform your courtroom advocacy? So the first thing I'm going to suggest is that there was, in the first workshop, there was a session on social workers and attorneys working as a team. And that is an amazing session. I unfortunately have to leave early to get started for here, but if you have a chance to go back and watch that session, you will learn in very granular detail exactly how they work together for courtroom advocacy. What I'd say generally, and frankly, we do have social workers, but we just started having social workers on our staff beginning of this year. So we're just getting started in how social workers utilized in courtroom advocacy. But in that instance, and what was talked about in that session, worker is fully a part of the team. They work together. The social worker actually goes out when they were talking about medically complicated cases. The social worker goes to the hospital. The social worker interviews the social worker at the hospital, the nursing staff. The social worker talks to the doctors if they can, and then communicates that directly to the attorney. The attorney prepares their direct and cross-examination based upon the information that's being provided by the social worker. Keep in mind, though, there's this very important divide. The social workers who work in our office will be not testifying as witnesses. They are not our experts. They are part of our legal team. The attorney-client privilege applies as long as they're part of the legal team. Therefore, they are not a mandatory reporter as part of our legal team, and they can't be asked about what they have seen or heard from the parent. So they're not acting as experts in the courtroom. They are an advocate as part of the team.
I think they can also help you as a team member be more trauma informed in the way that you're coping with your parents. I think they can help with motivational interviewing of parents and helping develop and build trust for families as you get appointed to them and they don't know you and they've already been through the system, often in a traumatic way because they're generations of removals into this. I think that social workers do a very good job of keeping particularly the lawyers centered on being trauma informed in the way that you're talking to your clients. And also they can help the parents really understand what's going on in the system and help get them access to services and resources that might help ameliorate their own trauma and create stronger parenting for them as you go forward and trying to be successful in avoiding an adjudication or a disposition and termination. So the social workers really, I can't say enough about what important members of the team they are.
So, Carlin, I don't know if you can see the questions. There is a very specific question that's been asked about a situation. I don't know if you can read it or you want me to read it to you.
I was just looking for that article, which I sent to John. So if you don't mind reading
sure. It says,
the question for me.
Carlin, it says, what about when a relative caregiver takes in a child with RAD and then DFCS uses this attachment info against the relative caregiver? That is, the child isn't even attached to you.
Wow, that is the mental gymnastics that they're jumping through to use that against you. Yeah, I mean, look, I think that would be a really good opportunity to focus on treatment and rehabilitation. Everything that we talk about, all of these changes, we are complex humans and we're also really resilient. A diagnosis of RAD, can be treated through therapy and through certain family therapy, especially. I would be really concerned why a diagnosis is an automatic removal. Again, I feel like the mental gymnastics that they're jumping through it's a reach, if that makes sense. Does that answer your question?
I hope so. It's hard because they can't. I wish y'all could talk to us. But I do think it is very important, the distinction, particularly where you're not yet using social workers on your multidisciplinary teams or incorporating them into your multidisciplinary teams. The distinction, and it's particularly if you've come from a criminal side, the distinction between forensic social workers and clinical social workers is very important because of that attorney-client privilege. And someone said they didn't think that the hospital social workers or nurses would talk to our social workers. And they may not, but you should go in there with a release and try to get them to talk to you because you're a representative of the client, and the client has the right to their medical records and to their medical information. And if they don't and they are called to testify, then by golly, you can ask them about the fact that they won't talk to your social workers and build that into your bias cross.
I would say I was really surprised recently when our social worker called up a social worker, a hospital social worker, and the hospital social worker made some incredible admissions that they never would have made to a lawyer who called them. So I think it's true. Many times they won't talk to you, but I've been surprised in at the session I was watching previously, the social worker from the Bronx, she goes into the hospital and many times they do talk to her. And I think we've been successful ourselves as attorneys calling and talking to child abuse pediatricians and asking them questions, and they'll talk to us and they'll give us their opinion. So I think that because they don't view themselves as on a side, they think that they're being professional. So they'll talk to you, and a lot of times that's true of nurses and others in the hospital. And then you may find a Carlin in there too.
I'm a testament. Yeah. I was radicalized by working in a hospital. It's awful. It's like working in a jail. But we developed a really good, really good rapport with the Baltimore City Public Defenders. So you might find somebody that's, surprises you.
Well, and I think we often make assumptions that people aren't going to talk to us because we sort of feel that downtrodden feeling. You don't know until you ask, and sometimes half our job is just winning people over. And we need to, I say stand strong, and I'm very big and ranty and like go in and make them listen to you, but also know the most and try to win them over, because you get more flies with honey in this job for certain than with vinegar. And so whatever you can do to get the most information to help your client, the better. But social workers tend to be a little bit better than the lawyers do, if I'm just stereotyping. And I am a lawyer. I get it. I sort of perceive myself as recovering because I don't do so much direct representation anymore. But I learn every time I'm in a room with a social worker, and particularly I think the lawyers would be well served to listen to the ideas and notions of the social workers on a team, because they're thinking about things with a brain that hasn't been ruined by law school and the Socratic method. So I just found out I could have pushed a button next to their names and let them talk to us, but now it's a little late in the going. So I'm sorry we didn't get to hear y'all, but if you have anything left, put it in the chat. It's hard to mind both. Otherwise, I just want to thank everyone on here for doing the work that they do. I've learned so much from being paired with David and Carlin and having this opportunity to speak to you all. I really admire the work that you do for parents, and this is a really strong social justice movement that I'm proud to be a part of, and thank you all for doing this work. See you at the rest of the
Thank you so much.
next year at the conference. Yes.